Just going to do a brief introduction, talk about myself and Wild Earth Guardian. So my name is Judy Brower. I'm the Wild Places Program Director at Wild Earth Guardians. And Wild Earth Guardians is a nonprofit conservation organization. We're based in Santa Fe, New Mexico, with offices in 6 other states, 6 other Western states. I'm coming to you from Boise, Idaho. Guardians just celebrated its 30th anniversary. And our 4 programs that we currently have are Wildlife, Wild Places, Wild Rivers, and the Climate and Energy Program. And I'm the manager of the Wild Places Program. We believe in nature's inherent right to exist and thrive. And through these 4 programs, we protect and restore the wildlife, wild places, wild rivers, and health of the American West. And Chris Krupp, who is our presenter this evening, he is an integral part of the Wild Places team, focusing on keeping public lands in public hands and preventing public land grabs by private industries and individuals. Chris is one of the preeminent experts on public land realty, meaning public land trades and sales. While some areas are protected from development, such as national parks, supposedly national monuments and wilderness areas, most public lands are subject to exploitation and privatization. And as Chris will discuss, the protection of national monuments is no longer assured until we win our lawsuit, of course. So first, we do have to recognize that the first public land grab in this country were from the indigenous people. The doctrines of manifest destiny and the doctrine of discovery were racist convictions that non-Christian people could not govern themselves or put land to productive use, and were invoked as justification to steal tribal lands, kill native peoples, and exploit their resources. Forest Service and BLM lands, particularly those including the monuments that we're going to talk about tonight, were originally tribal lands, and they are still very, very important to tribal culture and tribal life. Today, public land grabs are still being waged by wealthy interests and industries that are lobbying their friends in Congress, pressuring federal agencies, I'm having a hard time speaking, and supporting the message of radicals like the Bundy family, that they are the rightful owners of public lands and can do with them as they see fit. Chris's work focuses on preventing bad public land trades and sales, as well as preventing, these days, the effective privatization we're seeing through rollbacks of environmental laws and policies that are making it easier for industry to destroy public land through mining, oil and gas development, logging, grazing, and motorized use. And that's what's happened to the Bears Ears and Grand Staircase-Escalante national monuments. These unique places, and particularly their Native American historical sites and areas sacred to the tribes, should be protected through the national monument designation. Instead, the Trump administration, at the behest of its industry cronies, significantly reduced their size and eliminated tribal management to allow mining, oil and gas development, more grazing, and motorized use, which will ultimately destroy them. And Chris will talk a lot more about that. Quick housekeeping. We have a few more people joining us. Again, my name is Judy. We are going to use the chat ability. So if you have a question, and we already have our first question, and Tom, Chris will answer that question, I promise. Why are these lawsuits taking so long? That's a good question. We will get to that. So please, we will have time at the end for questions, but keep typing them in. I'm going to be monitoring both Facebook and our Zoom questions, and we'll be asking those of Chris when we get towards the end of the webinar. Okay, and we will also provide a follow-up email with Chris's contact information. So if you have additional, I guess I better turn off the sound of my phone. If you have additional questions, Chris can answer them. Okay, let's get started. Chris, it's all you.
Could you go to the second or third slide?
Or that's our second slide. I should have got that sooner. Third slide.
So here's kind of an overview of what we're going to talk about. We'll talk about the 2 monuments themselves, and their original and Trump proclamations. I'm going to provide a brief history of the Antiquities Act, which was used to protect these two sites and is the basis of our lawsuits. And I'll go over the status of the litigation and talk about why more than 2 years later we still haven't gotten any ruling from the court. And we'll also talk about the new management plans that have been put in place on both the monument lands and the former monument plans, or monument lands, I'm sorry. Next slide, please, Judy.
I'm trying, I'm getting it. There we go.
So I'll start with Bears Ears. Bears Ears National Monument was designated by President Obama, one of the last acts of his presidency on December 28th, 2016. And his proclamation directed the protection of Indian sacred sites and traditional cultural properties inside the monument, and provided access by the tribes for traditional cultural and customary uses, such as the collection of medicines, berries, and other vegetation. Bears Ears is in southeast Utah, and it's home to cultural resources that date to 13,000 years ago. Ancestral Puebloans started inhabiting the area about 2,500 years ago, and important ancient Pueblo sites such as Dollhouse Ruin and Moonhouse Ruin survive to this day. There are also incredible paleontological resources inside the original Bears Ears boundaries. And recent research was offering insight into the transition from marine life to land life, and from reptiles to the transition from reptilian life to the first mammals. Bears Ears also has tremendous diversity of plant life. There's subalpine fir at the highest elevations in the monument, and yucca and cacti in the canyons, and a large number of wildlife species, including large animals such as mule deer, elk, bighorn sheep, black bear, and 15 species of bats, and 11 raptor species have been found inside the monument. And dear to our hearts at Guardians, the largest contiguous critical habitat for the threatened Mexican spotted owl is on the Manti La Salle National Forest portion of the original Bears Ears Monument. Could you go to the next page, please, Judy? These are 4 different languages, the words for these namesake buttes that you see in the background. And not only are those the words for these 2 buttes, but those words actually translate to Bears Ears in all the languages. So it's well known for an incredibly long time as a landmark in this part of the world. Could you go back? I'm sorry, could you go back? The proclamation created a commission of 5 local Native American tribes that were to offer guidance and recommendations for the protection and management of Bears Ears. Those tribes are the Navajo Nation, the Hopi, the Ute Mountain Ute, the Ute Indian tribe of the Uinta and Ouray Reservation, and the Pueblo of Zuni. And all those tribes have ancestral ties to the region. And I should say that the Obama proclamation was already a compromise from the 1.9 million acre monument that the 5 tribes had proposed. So I'd also like to point out that though the original proclamation gave the 5 tribes a guidance role, it didn't grant them co-management authority, which was what the 5 tribes had been seeking with the original designation. And the 5 tribes are currently developing their own management plan for the original Bears Ears proposal of 1.9 million acres. And they'd like to offer their vision for the future of this important place through that document. Could you go to the next page, please, Judy? Thank you. I'd like to thank Grand Canyon Trust for allowing us to use this map and the map that's going to show the reductions to Grand Staircase as well. So President Trump made a huge production out of these monument reductions. He flew out to Salt Lake City to make a speech, and he signed the proclamations in front of state government officials as well as Utah's congressional delegation. It was almost certainly intentional that Trump's proclamation makes no mention of Indian sacred sites or traditional cultural properties as the original proclamation had. In terms of what was lost, you can see that it was an 85% reduction in land base. And so you'd expect an incredible amount of archaeological loss. And Friends of Cedar Mesa, a local group that helps monitor sites within the monument, estimates that 74% of Bears Ear's known archaeology was placed outside the original boundary with the second proclamation. Iconic places such as Valley of the Gods and nearly all of Cedar Mesa are also outside the new, smaller boundary. Next page, please, Judy. Grand Staircase-Escalante was designated by President Clinton in September of 1996. His original proclamation identified paleontological, archaeological, and biological diversity as objects of national importance. This is an archaeological hotspot. At least 25 species of dinosaurs have been discovered here since the monument was designated, including several species of ceratops and tyrannosaurs. Like Bears Ears, Grand Staircase-Escalante was also home to ancient pueblos. It also has an incredible amount of biological diversity. A 2018 study found that 660 species of bees could be found inside the original monument. And scientists believe that Grand Staircase-Escalante is one of the best places in the world to study the past effects of climate change. Next page, please, Judy. This reduction was a little bit smaller in terms of percentage, only 47%. I say only. That's a third, or excuse me, nearly. It reduced it in a third in size, so 47% reduction. Numerous sites have been lost here too, including the Toadstools, Eagle Sinkhole, Chimney Rock, and Peekaboo Slot Canyon. Next slide, please, Judy. Regarding litigation, I'd like to say first that we are well represented by Earth Justice, as are the co-plaintiffs in our two particular lawsuits. And the case was filed in federal district court in Washington, D.C. The Trump proclamations came down on December 4th, and by December 7th, 5 lawsuits had been filed. 3 separate suits over the Bears Ears designation, and 2 separate suits regarding Grand Staircase-Escalante. The 3 Bears Ears suits have been consolidated, as have the 2 Grand Staircase lawsuits. And both of those consolidated cases now are in front of the same judge, Judge Tanya Chutkan, who was appointed to the bench in 2014 by President Obama. The government wanted the lawsuit transferred to a friendlier federal court in Utah, and we fought that, opposed that, and the court denied that motion to transfer about almost more than 10 months after we originally filed our complaints. there's been several interveners in the case on the side of the government and President Trump. There's the state of Utah, 3 counties in Utah that contain these 2 monuments, San Juan, Kane, and Garfield counties, and the American Farm Bureau and the Utah Farm Bureau. Almost 2 years after the lawsuit was filed, we finally were given the motion to dismiss by the government was finally denied. And that allowed us to get around to setting a schedule for briefing, filing documents in support of our arguments and opposed to the arguments of the government. That began early in this year. And today actually is the date for the final brief to be filed by the interveners. So the case is now squared up for the judge to evaluate the merits of both sides' arguments and issue a ruling on summary judgment. Next slide, please, Judy.
Chris, do you want to talk about any reason why it took so long for the case to continue? I guess we can't.
A lot of this is the case moves along at the judge's timeline, and she has an incredible amount of discretion over that. It took a while to figure out all the interveners. There was a lot of briefing regarding motions to dismiss, and the judge wanted to, at one point the judge wanted to reconsider everyone's standing and ask for additional briefing. For guardians and our fellow plaintiffs in our suits, briefing is not an issue, but the government has been challenging the briefing in one of the 2 other Bears Ears lawsuits. It's just I can't really say why it has taken that long.
Okay.
The court moves at its own pace.
A comment from Tom. He said he thought San Juan County had dropped out of the suit. Do you know that?
I don't know. I had not read that, but it's entirely possible. There's a lot of documents submitted, and I can't say that I've read every single one.
Okay. And I'm just going to stick with another question because it's based on the litigation. Do you expect the judge to ask for oral argument on the summary judgment motions? Is it scheduled, or will the judge wait till after receiving the motions and responses and replies on summary judgment?
It has not been scheduled, but I would expect the judge to ask for oral arguments.
Okay.
So, like I said, our case is based on the Antiquities Act of 1906. We are alleging that President Trump violated the Antiquities Act in the proclamations that reduced the size of these 2 monuments. So the impetus for the Antiquities Act was widespread looting in the last quarter of the 19th century in the Four Corners region. People were just discovering this region, starting to explore the further corners of the area, and we're coming upon a lot of incredibly valuable scientific sites, and they were looting these places. And archaeological societies at the time were very concerned and informed Congress and the Interior Department of the problem, and let them know that other nations had laws on the books to prevent just this sort of looting inside their borders. But what soon became apparent was that by the time Congress could consider enacting legislation to protect a particular site, the looters had cleaned that area out and moved on to the next place they had found. So eventually Congress came up with the solution of allowing the president to protect public lands that had such sites by reserving them to protect the scientific and cultural objects of national importance. So the rationale for that was I'm sorry, Judy. The rationale is familiar. You grant authority to the executive branch for times of emergencies, as it's best equipped to act quickly, and then the more deliberative legislative branch can review those decisions and overrule them if it feels that's necessary. Thanks, Judy.
Wow. So I guess that this administration is throwing that all on its head right now. Acting quickly in emergencies.
Yeah. So applying the Antiquities Act to our litigation, our primary argument is a straightforward one, that the text of the Antiquities Act is essentially a one-way ratchet that grants the president only the authority to declare and designate national monuments. So you can see the sentence or the clause in blue there. The President of the United States is hereby authorized in his discretion to declare by public proclamation. Nowhere there is there any mention of reductions or redactions or boundary adjustments, anything of that nature. This is important that that's not mentioned because under the Constitution's property clause, Congress, not the president, has authority for managing the nation's public lands. Congress can delegate that authority via legislation, but any authority that isn't delegated remains with Congress. So in addition to declaring these biological, cultural, and scientific objects of national interest, the president was given the authority to reserve public lands that were needed to protect those objects. That's the rust-colored clause there, may reserve as a part thereof parcels of land. And I should mention that while the text does limit reserved lands to the smallest area compatible, that's the clause there in green, the limits of which in all cases shall be confined to the smallest area compatible. Long ago, the Supreme Court ruled, it was 1920, that those reservations, though they are supposed to be the smallest area compatible, can nevertheless be quite expansive. The Grand Canyon National Park was originally designated as a national monument under the Antiquities Act by Teddy Roosevelt. That was done within a couple of years of the Act's passage. And a local politician and businessman wanted to make a mining claim on the lands that Roosevelt had reserved for the monument. So he filed a lawsuit that said Roosevelt's reservations were far too large to comply with the smallest area compatible language. And the court looked at it, looked at the Grand Canyon and said that objects of scientific and historic interest could reasonably encompass all of the Grand Canyon. This case is Cameron versus the United States, if you want to look it up. And this precedent set in this case has been relied on in every single monuments case that has gone to a US Court of Appeals.
Hey, Chris. A question from Hank. This is a long question, but I'll try to shorten it. So has the question of the president's authority to shrink or make minor withdrawals of a size of a monument ever been litigated before?
Could you say that again?
So has the president's authority to make any modifications to a national monument ever been litigated in a federal?
No, it has not.
Okay. So this is a very novel case.
Yes.
Okay. Have there been occasions in the past where presidents have made minor withdrawals of land, but weren't litigated?
There have been, presidents have in the past made even major reductions to national monuments.
Okay.
Yes, but they have not been litigated.
Ah, got it. Okay.
So we have a second argument in support of the Grand Staircase-Escalante original designation. That's that Congress has twice modified the boundaries of Grand Staircase-Escalante with legislation for land exchanges with inside the boundaries of the original monument. As many of you may know, when states joined the Union, they were given 2 sections of land in each township for typically reserved for funds, a revenue source for their public school systems. And there were many of these parcels inside the boundary of Grand Staircase-Escalante. And there was Congress passed a law that directed a land exchange in which Utah was able to trade out of its parcels that were inside the monument for public lands elsewhere in the state. So that legislation serves to ratify the original boundary. And that's important because the president can't override acts of Congress. And our interpretation of the act comports with the reason the act was written. Now, the government's argument all comes down to this, the clause regarding the smallest area compatible, but it's not saying that the president has to, can only designate small areas of land that narrowly fit the objects of importance. That argument was disposed of in 1920 with that other case, Cameron versus the United States. So the government is saying that that clause is establishing an ongoing duty to make sure that the minimum necessary amount of land is reserved. So basically, they're saying that the president has a duty to revisit these monuments and make sure that the amount of land currently designated isn't greater than what is now the smallest area compatible. It's a pretty crazy reading of the law, in our opinion. A common sense reading of the text would show that that smallest area clause limits the president's reservation authority at the time of the designation, but it doesn't confer any separate ongoing power to dismantle the monuments.
And that would be
another argument is that the Congress meant to grant the president authority to adjust the boundaries or reduce the size of these monuments, but there were contemporaneous statutes from Congress at that time that showed that if Congress had wanted to do that, it knew how. So the legislation that established the Forest Service, which was in 1897, and the legislation which established the Bureau of Reclamation, which was in 1902, both those pieces of legislation gave the president the power to amend or revoke withdrawals of public lands in addition to making those withdrawals. One other argument you'll hear the government make, I'm sorry, Judy?
Oh, I was just gonna say it would kind of be a mess if presidents could just come in and dismantle and create, dismantle monuments at their will. One president makes it smaller, the next president makes it bigger, and that would kind of be a disaster.
Yeah, there would be no certainty at all to the boundaries of any of these monuments. It would be a nightmare for management purposes. So yeah, this other argument that you'll hear the anti-monuments crowd make is that the presidents have long relied on this implicit authority in the Antiquities Act, what they claim is an implicit authority to reduce the size of the monuments or adjust the boundaries. And the Congress, they're saying the Congress has essentially acquiesced or okayed this revocation or reduction authority by not acting in the past when a president has moved to reduce the size of monuments. They're really overstating their case. The executive branch has gone back and forth as to its legal interpretation, whether it thinks that the president has such authority. And the last time that a reduction was done was in 1963. It was a minor adjustment to Bandelier National Monument in New Mexico by President Kennedy. And what's really relevant there is that that was before the passage of the Federal Land Policy and Management Act in 1976. And with that act, Congress made clear that it was reestablishing its preeminent authority over public land, and it revoked a lot of past presidential authority to adjust withdrawals. So shortly after the proclamations from President Trump, BLM and the Forest Service moved to develop new management plans for the areas that were originally covered by the monuments. Management plans are high-level planning documents that set the direction of management for an area of public lands. Federal land agencies are required to develop these plans, and all specific actions taken by the agency inside those areas must comply with these high-level plans. In terms of developing these plans, it was a rushed, closed-door process, and it was generally devoted to opening up land for inappropriate development with little input from the public. With Grand Staircase-Escalante, there was an existing monument management plan in place because the monument was designated in 1996. And so BLM developed two new plans for the former monument. One covers the former monument land that's now just managed as typical BLM public land, and the other covers the public land inside the new illegal monument boundary. The Grand Staircase-Escalante plans open up hundreds of thousands of acres of the original monument to drilling and mining and other uses, extractive uses. For Bears Ears, that's co-managed by the Forest Service and the Bureau of Land Management. And they were managing the original Bears Ears following the direction of President Obama's proclamation, but Trump's proclamation was so soon after the original one that the Forest Service and BLM hadn't even had time to finalize monument management plan for Bears Ears. So for Bears Ears, the two agencies collaborated to develop separate plans for the two distinct units of that national monument. And in Bears Ears, off-highway vehicle use, additional public visitation of important but little-known cultural sites that are not often visited. There's been pinyon juniper clearing for the benefit of grazing that's going to be permitted under this new plan. And again, former lands have been opened up to mining and drilling. And one other important thing for Bears Ears, the consultation role for the 5 local tribes has effectively been eliminated. So one thing to note, these are, like I said, high-level planning documents. If there are any specific actions that are to take place under the guidance of these plans, there is additional public process required under the National Environmental Policy Act. It's our belief that we're going to win these two lawsuits, and if that's the case, the new monument management plans and the new plans that cover what are now called former monument lands will be thrown out along with the proclamations. We don't think that BLM and Forest Service followed the law in implementing these new plans, but so far we haven't brought any legal challenges to those new plans. We're closely watching them, the monument lands, for any actions on the ground that we feel may rise to the level of irreparable harm. And the Southern Utah Wilderness Alliance, one of our co-plaintiffs in the two cases, has someone that goes and checks in at the BLM field offices to see whether there have been any new mining claims filed. And that person also goes to the monuments and makes site visits at these existing claims to determine whether there have been any new site disturbances. SUA then updates our group of co-plaintiffs as to whether there's anything that could rise to a level of irreparable harm. If that were to happen, we would then move for an emergency injunction before the court that's deciding these two cases.
Hey, Chris, another question from Hank. Is the reason for the lack of litigation about the plans related to the Supreme Court's decision that blocked a management plan challenge because it wasn't right? That's the Ohio forestry case.
Yeah, that's a potential issue. We also, the threshold to get an emergency injunction is rather high in the DC Circuit Court, and we feel that we don't feel we have something that would certainly merit an emergency injunction at this time. And we've now got the briefing completed. There was some concern that challenging the plans may even further delay reaching the merits on this case. So we're taking a wait and see attitude regarding the management plan decisions themselves.
But if something comes up, if there's a big action, then you're going in.
Yeah.
Nice. Okay.
So what's next? As I said, all the documents necessary for the judge to decide the case have now, as of today, been submitted to the court. So now the judge will evaluate the merits of each side's arguments and the legal reasoning, look at the legislative history and the language of the Antiquities Act, and come to a decision. And as we've alluded to, that could come quickly, but there could also be a significant waiting period. It could possibly even come after the presidential election in November. We hope it's sooner than that because we feel we have a winning case on the merits. But again, we're somewhat beholden to the judge's timeline on this, or I should say not somewhat, but largely. There's almost certainly going to be an appeal, at least to the DC Circuit Court, because there's a right to an appeal to the circuit courts. So that would be the case. Even if the judge finds that Trump violated the Antiquities Act, and if Biden were to win the presidency, win the election, and his administration could decide, we don't like these proclamations, we're not going to appeal our losing case. But like I said, there were interveners in the case, and they are most likely going to want to appeal this regardless of what the government wants to do. And they have a right to do that as interveners without the government pursuing an appeal. There's also a possibility that President Biden could issue a proclamation shortly after taking office that essentially reverses Trump's reductions and restores the original boundaries of the two monuments. It's even a possibility that if Democrats were to take the Senate and Biden wins the presidency, there could be legislation passed that restores the original boundaries. And it seems pretty clear that a future president could not then change those boundaries.
Nice. So we have our work to do when you know who gets elected, when Biden gets elected. I'm saying when. I have hope.
So for more success on public lands, we need advocates like everyone that has tuned into this webinar.
Absolutely.
So some of the things you can do, if you visit these places or other national monuments, let local businesses and, more importantly, local elected officials know that you oppose Trump's illegal reductions and support the original monuments. If you visited in the past, you could email county commissioners in these 3 counties, San Juan, Kane, and Garfield, and let them know you're not coming back until the original boundaries are restored. You know, Utah and the counties have been making they've often made the economic argument that, you know, monuments lock up public lands and we can't develop them. Well, the data is pretty clear that counties' economies benefit from monument designations. So I think it's in our best interest to let local government officials know that we're not going to be giving them our money if they continue to oppose these national monument designations. You can also contact your federal representatives and let them know that all Americans have a constitutional interest in protecting public lands in Utah, and that these lands benefit not only Utahns, but all of us. Congress has historically deferred to a state's congressional delegation's interests when it comes to that state's public lands issues. So that's why bills such as America's Red Rocks Wilderness Act for Utah and the Northern Rockies Ecosystem Protection Act, which would create additional wilderness in Montana, Idaho, far eastern Washington, and Wyoming. That's why these bills languish in Congress. They're blocked by the senators from Utah, or the senators from Idaho and Wyoming, despite overwhelming public support nationwide. And we're going to need to eventually overcome that, and that's going to take a concerted public effort. So we need to let our officials know that we want our interests represented in the halls of Congress. Something else you should consider doing is, it's the 50th anniversary of the founding of the Native American Rights Fund. They are representing the tribes in the Bears Ears litigation, and they're doing a great job. So I would ask that you consider, if you have the means to do so, contributing to NARF so that they can continue their important work preserving tribal existence and protecting tribal natural resources. A couple of more selfish things you can do, selfish in terms of Guardian's interests. If you could sign up to receive Guardian's e-news, that would be great. There are ways to limit the number of emails you receive to 1 per month. And you can also identify which particular programs you are interested in receiving news about: public lands, wild rivers, wildlife, or climate and energy. It'd be great if you could sign up for all 4, but if you only want to do one, you can pick and choose. And finally, please follow us on our social media, and the addresses and handles are provided on the page. And we will provide those in our follow-up email as well.
Great. We have one more question from Betsy. Betsy Gaines. Thank you, Betsy, for joining us. Betsy is a dear friend of mine from a long, long time ago. And I just have to put in a plug for Betsy Gaines's new book called American Zion, Clive and Bundy, God and Public Lands in the West. So you can get that at your local bookstore preferably, or even on Amazon. Betsy and I will be, Betsy will be doing another presentation that we're co-sponsoring on the 16th. So look out for information on that on our social media channels and our e-news. Betsy asks, in light of the ongoing lawlessness, if you win before the election, do you think the BLM will disregard the court's ruling? And will the Bundys and Phil Lyman stage another recapture Canyon action?
I hesitate to make a prediction on the latter. But I do believe that BLM would honor a court ruling.
Yeah, I actually think a lot of, especially the archaeologists and scientists within BLM are very upset with this.
Yeah, when Grand Staircase-Escalante was first designated and funded in the initial years after its designation, there was a really big effort to devote serious resources to developing an archaeology program inside Grand Staircase, and funding for that has dissipated over the years. But I think there's still a lot of support in BLM for the two monuments. So I don't think that they would defy any court ruling. I mean, Trump would probably tell them to by a tweet or something, but they're not gonna. It's not gonna do that.
Yeah.
And I can't. Betsy would know better than I do what would motivate people like the Bundys and Phil Lyman to make their next move.
Yeah, unfortunately.
So I'll defer to you on that, Betsy.
Or William Penley. We got William Penley in charge of the BLM, so who knows what he's going to do. Yeah. Any other questions? If you have any other questions, answer them quickly. We thank you so much for joining us. You will get a follow-up email with all of this information about what you can do, as well as Chris's email. Yes,
if you have a question, regarding any of the briefing, or if you want the briefing, it's all publicly available. But rather than taking the time to log on to Pacer and find it, if you even know what Pacer is, if you want some of the briefing or whatever you want, I can get it for you, and I'm happy to answer any questions regarding what we've argued so far and just the stance of the litigation.
Yeah, it is an ongoing battle. It may be short, it may be long, we will see. But thank you all so much for joining us. And just so you know, a lot of national monuments, other national monuments are under attack right now. The Trump administration is trying to increase grazing in a lot of monuments. They are trying to, do other things like do some pinyon pine juniper removal so that there can be more grazing, and we're sure there's some other things, and we're keeping track of that as well. And if you have your favorite national monument, and if you hear of anything nefarious going on in those national monuments, let us know, because we are happy to jump in and help fight to protect the national monuments that are so important for not only various Native American tribes around the West, but also just as Bears Ears and Grand Staircase, just incredible history and archaeology.
Yeah, just last week, Department of Interior opened up a marine national monument on the Atlantic coast to commercial fishing. So I hadn't heard anything about that until the announcement. Obviously, it's on the East Coast and it's a marine monument, but I think that took most people by surprise.
Yeah, it shouldn't have, but it did. And I also do want to mention that Betsy Gaines is on our board of directors. We are so happy to have her. She's been doing activism and research for a very long time, so we're proud to have her on our board. And I think with that, if there's no other questions, thank you all again for joining us. We really appreciate you being here and spending your evening with us. Here's Chris's contact information, but again, you will get Chris's contact information in the follow-up email that's sent. And thank you so much. And Tom Ribe says, thank you, excellent presentation. So we appreciate it. And we'll see you the next time.
Thanks everyone for joining.
All right, thank you.
Have a good night.
Now let's see if I can figure out how to end this. Stop video. Let's see. Stop. Pause, share. Stop share. Okay, there we go. Now I can end it.
I see Marlise is still lurking. Okay.
Yep. Okay, awesome, Chris. Thank you. Is anyone still here? Or is it just us?
Just Tom and us.
Okay. All right. Awesome, Chris.
Thanks, Tom.
Thank you, Tom. Appreciate all your excellent questions. Whoop. And Chris, I'll talk to you tomorrow.
All right. Have a good night.
You too. Take care.
Bye-bye.